Picture this, a federal courtroom in Houston, Southern District of Texas. Plaintiff's table, 3 people. A graphic designer and food creator from Austin who had spent 4 years building her brand around her grandmother's recipes. Original videos, original presentation, original voice. A documentary-style filmmaker from San Antonio who had spent 6 months developing a visual concept he had never seen executed the way he was executing it. A copywriter and essayist from Houston who had turned her personal writing about grief into a content series that 40,000 people showed up for every single week. 3 creators, 4 years of work between them, combined following at the time of filing, approximately 93,000 people. Defendant's table, 1 person, a legal team billing at $400 an hour, and a brand valuation of approximately $4.7 million in annual partnership revenue. Kayla Monroe, 29 years old, 2.3 million followers. She sat at that table the way people sit when they are used to being the most visible person in the room. She had dressed carefully. She was composed. Her lead attorney, a man named Richard Ames, was one of the better intellectual property litigators in this district. I knew his work. He was going to make this as hard as the law permitted. I want to be honest with you about something. In 32 years on and around the federal bench, I have seen cases that looked complicated and turned out to be straightforward once you followed the reasoning. And I have seen cases that looked simple and turned out to require a level of precision that I had not anticipated. This case looked like the second kind. It turned out in the end to be the first. But I did not know that on the morning I read the complaint, and I am going to take you through what the reasoning actually required, because the reasoning matters as much as the result. I'm Victor Lawson, Federal Bench, Southern District of Texas. I want to show you what this case actually required, not just what happened, but how we got there. Subscribe to the Verdict Vault, because what I do here is show you the reasoning, all of it. No shortcuts, no summary. The vault opens all the way. I'm going to show you the reasoning, all of it. Let me start where I always start, with what was genuinely hard. Copyright in digital spaces is not simple law. I'm not going to pretend it is, because if I did that, I would be doing exactly what the defense wanted, collapsing a complex problem into a simple narrative that served their client. Digital content exists in an ecosystem where ideas move fast, where aesthetic trends propagate across platforms in 48 hours, where 2 creators on opposite coasts can independently develop nearly identical visual concepts within the same week without either having seen the other's work. This is real. Fair use is a real doctrine. Common creative vocabulary is real. Inspiration is real, and it is not theft. I have said those things from the bench, and I believe every word of them. So when this complaint arrived, I read it the way I read every complaint, looking first for what would be hard to establish, not for what would be easy to assert. And in a digital copyright case, the hardest thing to establish is not copying. Similarity is observable. The hardest thing to establish is willful copying. The difference between a creator who encountered a similar idea and developed it independently, and a creator who located your specific expression of that idea and reproduced it. That is the line. That is where every case in this category lives or dies. I was going to hold the plaintiffs to that line. I was not going to let sympathy for 3 small creators or skepticism toward a large one substitute for proof. The 3 plaintiffs were Maya Chen, 31, food creator and recipe content developer based in Austin. Daniel Reyes, 38, short-form documentary filmmaker based in San Antonio. And Avery Walsh, 43, essayist, copywriter, and content creator based in Houston. Their cases had been filed separately and consolidated before me when the common defendant and overlapping factual basis became clear. The consolidation was appropriate. It let me see the full pattern rather than evaluating each instance in isolation, which is exactly how pattern evidence is supposed to be evaluated. The claim was this, that over an 18-month period, Kayla Monroe's content team had systematically located their original work and reproduced it. Not the ideas, not the general aesthetic direction, but specific expressive elements, specific caption language, specific visual compositions including documented color grading choices, specific structural frameworks that Avery Walsh had not only developed, but had written about publicly in her own creative process essays, which were time-stamped and archived. The timeline of reproduction, in 47 documented instances, showed derivatives appearing on Monroe's platform within an average of 61 hours of the originals. I want you to understand what the plaintiffs put in front of me, because the scale and structure of their evidence was part of the reasoning. This was not 3 incidents, or 5, or 12 claimed similarities. The exhibit ran to 47 documented instances over 18 months. The plaintiffs had built a chronological presentation. I am going to call it what it was, a timeline constructed with precision that laid out side by side the original post with its exact timestamp, the Monroe derivative post with its exact timestamp, and a granular analysis of what specifically had been reproduced. Not general similarity, specific elements, caption structure and language, visual frame composition, name series identifiers, thematic frameworks. I went through that exhibit piece by piece. This took time. I am not a person who reaches conclusions before I have looked at every item in the record, and I was not going to start with this one. Some of the instances were borderline. I want to be direct about that because the reasoning required me to be direct about it. 12 of the 47 instances under close examination showed similar subject matter and comparable aesthetic treatment, but did not demonstrate specific expressive reproduction in the legal sense. Two creators working in the same wellness lifestyle space will sometimes produce similar looking content independently. That is the nature of shared aesthetic communities. I set those 12 aside. I was not going to allow weak evidence to bolster strong evidence or allow strong evidence to compensate for weak. The remaining 35 instances held. Now, 35 instances of documented similarity is still not proof of willful infringement. I want to be precise about this because this is where Richard Ames made his best argument, and he made it well. Ames argued that in the lifestyle, wellness, and food content space, certain aesthetic vocabularies are genuinely communal property. Natural lighting on white or neutral surfaces, conversational first-person captions, narrative arcs built around personal transformation or seasonal change. These conventions are shared across thousands of creators. He argued that Kayla Monroe had developed her brand within the same cultural ecosystem as the plaintiffs, that they were all drawing water from the same wells, and that similarity of expression in a shared aesthetic community was not evidence of targeted copying. He cited cases, Feist Publications, Starbucks Corp v. Wolfsboro Coffee, real precedents, real arguments. He made them accurately. He also made the legal argument that I found most technically interesting, and I want to give it to you fully because it deserved full examination. He argued that copyright protection for a content concept or creative framework is limited by what the law calls the idea-expression dichotomy. Copyright protects expression, it does not protect ideas. You cannot copyright the concept of cooking with inherited family recipes. You cannot copyright the documentary short-form aesthetic. You cannot copyright the practice of writing personal essays about grief. These are ideas. They belong to everyone. Only the specific expression of those ideas is protected. This is correct law. I agreed with it completely. I told Ames from the bench that he was correct, and I watched him recognize that I meant it. Here is where it stopped applying to these facts. The plaintiffs were not claiming their ideas had been stolen. They were claiming their specific expressions had been reproduced. The specific caption language, in 14 of the 35 surviving instances, the language was near word for word, with changes that appeared to be deliberate minimum variation edits rather than independent composition. The specific visual compositions, Maya Chen had documented her color grading choices in production notes that predated the Monroe derivatives and showed the same custom white balance and shadow lift combinations. The specific structural frameworks, Avery Walsh had publicly named and described her essay framework in a creative process post that was indexed, time-stamped, and entered into evidence alongside Monroe's derivative, which used the framework with its 3 named sections preserved in the same sequence. That is expression, not idea, expression. And then there was the document. I want to be precise about how the DM exchange entered the record, because how evidence enters the record is part of the reasoning, not a footnote to it. The message was not obtained by the plaintiffs through surveillance or personal account investigation. It was not subpoenaed from Monroe's private communications. It was produced by Monroe's own legal team in a routine discovery response. Richard Ames's firm had requested and produced business communications from Monroe's content operations team, standard practice in content litigation to establish the workflow and decision-making process. Monroe's production coordinator had retained messages in the company's business communication archive as a standard operational record. Those records were produced. In those records was a direct message from Kayla Monroe to her production coordinator. The message was dated. I am not going to give you the precise date here because that would narrow the identification of a composite case, but the date was documented and it was relevant. It predated by 41 hours the post that most directly paralleled Daniel Reyes's documentary series. The message read, "Find the original and make it ours but faster." 6 words. Find the original and make it ours, but faster. Ames moved immediately to limit the interpretive scope of that message. He argued, and this is the argument I examined most carefully because it was the most sophisticated piece of the defense, that the message referred to a specific creative direction for a specific post, not a general operational policy. He argued that make it ours could be read as a directive to create an original version drawing from a trend, not a directive to copy a specific creator's work. He argued that find the original could refer to finding the original version of a trending format, not targeting a specific creator's specific post. He argued context. I read the message in the context of the full Discovery production. The production coordinator's archived records showed a pattern of activity in the days surrounding the message. Searches for named creators' accounts, screenshots of their posts, internal notes on publication timelines. The 41-hour gap between Daniel Reyes's post and Monroe's derivative was the shortest gap in the entire 18-month record. The message was sent in the middle of that gap. The context did not support the interpretation Ames was offering. Here is what the reasoning required. I want to show you the work, which is what this channel is for. The legal standard I was applying for willful infringement is found at 17 U.S.C. section 504C2 of the Copyright Act. Willful infringement requires establishing that the defendant knew their conduct constituted infringement or acted in reckless disregard of the plaintiff's rights. The standard does not require proof of malice or bad faith in the colloquial sense. It requires proof of knowledge or conscious indifference to the plaintiff's rights. What I had in front of me was 35 documented instances of specific expressive reproduction, with timestamps establishing consistent derivative timelines. A business communication directing the location of original content for reproduction with competitive speed. A production record showing the workflow that corresponded to that communication. A defense argument that could account for the aesthetic similarity in isolation, or the workflow in isolation, but could not account for all three elements together without asking me to believe that a series of coincidences had occurred with a consistency that coincidence cannot explain. Ames could give me one of the three. He could give me two. He could not give me all three simultaneously. When you follow the reasoning, that is where it leads. I issued my ruling in writing, as I do in cases of this complexity, because I wanted the reasoning documented in the record completely, so that any reviewing court would have the full analytical chain, not just the conclusion. The ruling ran 22 pages. I am not going to take you through all 22. I am going to give you the part that has been described in how this case was reported, the part that was read into the record at the conclusion of the hearing. Near the end of the written ruling, I addressed the inspiration defense directly. I wrote, "The defense's argument that inspiration is not theft is correct as a statement of law and irrelevant as applied to these facts, because what is before this court is not inspiration. What is before this court is a documented operational practice, reflected in the defendant's own internal communications and corroborated by the production record of locating original creative content, reproducing its specific expressive elements, and accelerating the timeline of publication. A practice described by the defendant in terms that leave no material ambiguity about its intent." I read that passage aloud from the ruling at the conclusion of the hearing. Ames was writing on his legal pad. Monroe was looking at the defense table surface. I want to say something about that moment, because I have thought about it since. The line has been described as humiliation. I did not write it to humiliate. I do not write sentences to humiliate. It is not a function I consider appropriate to a federal ruling. I wrote it because the defense had invested significant analytical energy in the inspiration argument. Ames had built his entire defense around the premise that what occurred was aesthetic inspiration in a shared creative space, not targeted reproduction. And the ruling needed to explain, with precision, why that argument failed. Not that it was a bad argument in principle, that it was inapplicable to these specific facts for specific reasons traceable through specific evidence. If that sentence felt like humiliation, it was because the gap between the defense's characterization of the conduct and the documented record of that conduct was wide enough to be visible from a considerable distance. I merely named the gap. The damages I awarded were statutory under 17 U.S.C. section 504. For Maya Chen, $120,000. For Daniel Reyes, $175,000, reflecting the higher number of surviving instances and the degree to which his documented work had been reproduced specifically. For Avery Walsh, $95,000. Total damages assessed, $390,000. I also issued a prospective injunctive order requiring Monroe's content operation to implement and document a content clearance process before publishing any material derivative of named third-party creators, with compliance reporting to the court for a period of 18 months. That structural remedy was important to me, more important in some respects than the damages, because the damages affect one case, and the injunction affects the practice going forward. Monroe's team filed a notice of intent to appeal. That is their right under the rules, and I respect it. I write decisions that can withstand appellate review. If the circuit disagrees with my reasoning, I want to know why, because that is how the law gets better. That is how I get better. That is the purpose of the appellate system, and I have never once resented it. What I reflected on after this case, and this is the piece I keep coming back to, the one that reaches past the specific facts, is a structural question about the digital economy that this case made concrete for me in a way that legal theory hadn't previously. 3 content creatives. Between them, years of original work. The economic mechanism by which a platform with 2.3 million followers absorbs the creative output of a platform with 40,000 followers is not mysterious. It is faster distribution, larger audience capture, higher brand partnership value. When the large account reproduces the expressive work of the small account within 2 days, the economic return flows primarily to the large account. The small account receives nothing. The creative risk, the time investment, the iteration, the development cost of an original concept was taken by the small account. The economic benefit of that risk was captured by the large one. If that structure operates without consequence, it hollows out the incentive system that produces original creative work. Why take the creative risk if the economic upside can be absorbed by whoever has the largest distribution? The Copyright Act exists in part because the people who built it understood that creative labor has economic value, and that value is destroyed if it can be taken without consequence by those with greater distribution power. This case did not resolve that structural question. One ruling doesn't resolve structural questions, but it named it cleanly in a documented record. That naming matters. Augustine wrote in the Confessions about the way concealed things surface, how what is hidden eventually becomes visible, how what we do in private is eventually registered in the record of what we are. Find the original and make it ours, but faster. That instruction was always going to surface. The person who wrote it had not considered the possibility that it would be produced in discovery, because people who give those instructions rarely think about what discovery looks like. But once it was in the record, everything else, the 35 instances, the timestamps, the side-by-side comparisons, resolved into a single coherent picture. The picture that had been there all along. What you conceal eventually surfaces. The record does not care how large your following is. Before you go, I want to ask you something real. What's one principle from this case that you'll carry with you? Not about copyright law specifically, about originality, about attribution, about what it costs to build something from nothing and what it means when someone treats that cost as their opportunity. Write it in the comments. I read every one of them, because those are the conversations that tell me whether the reasoning is actually landing. This is the Verdict Vault. Subscribe if you want the reasoning, not just the verdict, and share this, because someone you know is out there creating something real every week without knowing whether the law sees them. It does. And I want them to know that.